Hello and welcome to our webinar on new Digital Personal Data Protection Act 2023. On behalf of Cyberspy Consulting, I extend a warm welcome to all. I am Mehak Sharma and I am going to be your moderator and host for the event. So, before I invite our speakers, let us dive into today's agenda of this webinar. The agenda of this webinar is to explain key aspects of Data Privacy Act, that is DPDPA 2023, how businesses are going to be impacted by it, and how businesses can move forward with the compliance against DPDPA. This will be followed by a Q&A session. We have received a couple of questions offline, and I would request you all, if you have any questions, you can put them into the chat box. With this, I would like to introduce you all to our speakers for the event. It is my pleasure to introduce our esteemed speaker, Mr. Sudhir Singh. With over 2 decades of international experience in data privacy, cybersecurity and laws, information security, management, risk and compliance, and with a solid technical background, he has worked for many international renowned organizations like UN, NETS, DNB Bank Norway, AstraZeneca UK, HCL, Wipro, and HP. Moreover, Mr. Sudhir's dedication to knowledge sharing is evident through being a trainer and speaker for data privacy, cyber laws, and cybersecurity at various international platforms in different jurisdictions. He possesses a unique talent for making complex concepts accessible and easy to understand, enriching the learning experiences of his audiences. Today, we have the privilege of tapping into Mr. Sudhir's extensive expertise as he imparts valuable insights that will undoubtedly benefit us all. Please join me in welcoming Mr. Sudhir Singh to our webinar.
Thank you,
Sudhir,
Mac.
thank you, Sudhir. Sudhir will be supported by Mr. Naveen Sharma, Managing Director of Kentic Technologies. With over 30 years of experience, he is a seasoned IT leader specializing in designing and executive innovative delivery models and metric-based compliant operational structures for complex IT services, setting up businesses enabling solutions, controls, and robust processes for effective outcome and desired compliance, advisory services for data protection, privacy, and data governance. Please join me in welcoming Mr. Naveen Sharma to our webinar.
Yeah,
Now,
thanks, Mehak.
we should Now we should get started with the presentation. First, let's talk about the historical background of this particular law. We are all aware on 24th August 2017, the Supreme Court of India gave up a landmark judgment and established privacy as a fundamental right under the Constitution of India. And on 7th August 2023, Digital Personal Data Protection Bill was passed by Lok Sabha and was passed by Rajya Sabha on 9th August 2023. Thereafter, it received presidential assent and was published in the official gazette on 11th August 2023. The enforcement related notifications are yet to come out. For that, we'll have to wait. The objective of this webinar is to increase the awareness of implications of data privacy in context of Indian market. While data privacy is already a matured subject in US and Europe geography, it is good news that Indian government has finally prioritized data privacy. Now, it's about time that I call upon Mr. Sudhir Singh so that he can help us understand the vision of Indian government again around data privacy and some critical key aspects of this new law. And these are important definitions, applicability of provisions, the ground of processing, personal data, privacy notice, and consent management. Over to you, Sudhir.
Thank you for the wonderful introduction, Mahak. And I extend my thanks to the Kentik and Cyberspile inviting me here in this webinar. Yeah, uh, it has been expected by world, to see that India is introducing a kind of data protection law, because India is actually emerging, economy and country, which is coming up with unique capabilities, skill sets for world. Everyone is looking towards India, and I'm happy to say that, being an Indian, I'm also connected with various countries where they have been trying hard to introduce a data protection law. But if we see the journey, as you mentioned, uh, earlier we had this IT Act in India, and this IT Act 2000 was having some clauses around data protection and data privacy, but that was not enough, and the country really needed to have a sort of regulation which can address uh, the requirements for users, and also the requirements which is stated in constitution, the freedom of the individuals. And when I say freedom of the individuals, it is freedom of rights, freedom to speak, and freedom to express. So if we see the background, and everything is revolves around data. And if you see ancient time, we had data. The data was verbal, or data was in different kind of fonts and lipis. And then the data came into existence where human beings started writing on paper. It was manual form, but suddenly why there was a rush that everyone or every country would like to have a data protection law? Why that need is there? And the reason behind this need is actually it becomes the business enabler now. And when data comes, it is in digital form when we utilize it to perform any business or conduct any business. And another existence of the internet. So people are connected so well now. People are connected each other, and they are sharing their personal data. They are sharing their business data, research data, important data which is critical for their infrastructure to manage. So there was a need to bring some sort of regulation in place, and I could say that European Union has shown the interest in earlier days when they have introduced directives. However, directives have not, been enough implemented, and did not give a expected result. And thereafter, European Union introduced a law called GDPR. And if I could say, GDPR is actually a kind of very extensive regulation written by European Union, and many of the countries who are actually drafting and introducing their laws, they are actually referring GDPR. So I'm proud to say that I'm bringing a kind of experience where I have, advised more than large 15 customers to implement GDPR in Europe. So why this is in India now? Why Indian government wanted to have this data protection regulation? As I already said, we are the number one in population now. We are the youngest country. We are the one who are having largest startup numbers in the world. We are generating a lot of data every day, and that also contain personal data. So the reason behind to make the country as a digital India, as per the plan of the current government, and they would like to have a consolidated kind of framework where they could address uh, the cybercrime, the data governance, personal data protection, and the rights of the individuals together. They have this under their Digital India goals in 2026. So this is how the journey started, and we can also talk about a framework which Indian government is planning to introduce, and this framework contains various kind of amendments or drafting new regulation around the associated, which is associated with the data protection law. Yeah, this is existing on the slide now. So if you see the Digital India Act is a framework here, uh, which is more around interfaces towards the data protection law. The Indian government is also writing a data governance policy and also amending their Indian penal codes around the cybercrime. We already had a couple of clauses existing, but those are not enough. Also, the Digital India Act rules will be introduced soon. So this is not only Digital Personal Data Act which is introduced now. We could expect a couple of other regulation or policies coming from Indian government, which is actually focusing on bringing the country as a digital India, and that's why these efforts are being put there. Yeah. So regarding the Digital Personal Data Protection Act, uh, we have extensive data protection act written by government. It has been approved, as you mentioned, Mehak. It is already approved, but yet to be implemented. Couple of rules are needed to be written here, and these rules are more around how the data protection law will be implemented, and how the data protection board will supervise the and monitor the development around the implementation of the rule. So if we go to the next slide here, meanwhile we will jump to the next slide here. Naveen, would you like to add something here?
Yeah, sure, Sudhir, thanks. So, see, basically, when I look at it from a Indian business perspective, the kind of vulnerability we have in India business, so we are running a big risk of losing business which comes to us from UK and US just because of the way we handle the data and the private data. So, giving a small example, I mean, we all are aware that the personal data for us is like our medical data, is our Aadhaar card, is absolutely a personal data. Now, the way it is being handled today by the government agencies or the way the private banks and they collect our data, and we are really worried how it is being used. So the good news is with DPDPA in place, there will be a great initiative from the government to see to it that our data, which is personal to us, remains personal and is not misused. I mean, if you see today, if you surfing on Zomato and you are ordering something, all of a sudden you will see that there are artificial intelligence working in the background and capturing your taste, their moods, whatever you view in YouTube becomes the next automatic which comes on screen. So somewhere I think we are all vulnerable the way the technology is being abused, if I'll say personally, in terms of using the personal data, and they are affecting governments. They are affecting. If you see today, this election in India is not going to be a plain one-on-one. So there's a lot of digital drive going on, understanding who people are surfing on maybe the Congress side of it or the BJP or any other party. So it is important that our personal view remains personal to us, and we as an organization are taking a lead in terms of the finding the implication of mishandling of a personal data. When it comes to corporate, the penalties could be as high as 200 crore or 250 crores as defined by the government. So it can really shut down a running organization if a data is not handled well. So we have to see to it that we learn fast and that ignorance around data uh, privacy is taken care on priority, and which I think Modi government has taken a big initiative and to ensure that our business is safe going forward. Yeah, Sudhir, I
Thank
think
you.
that's it for my side, and I will keep on
Yeah.
adding my views. Yeah.
Thank you, Naveen. I completely agree with you. When it comes to data, it's not only data, it actually, associate with individuals, and individuals really looking towards the organization that they will process this data, responsibly. Uh, I see this act is win-win situation for both, for the organization. We call them data fiduciary in terms of DPDPA Act. But if you talk about GDPR, they call it data controller. And there are many other regulations where they use different terminology. Can we go to the earlier slide, please? Yeah. So it is this regulation is giving freedom to the individuals, because this data relates to the individual, and these individuals are actually owner of this data, and we call DPDPA term this individual named as a data principal. So when we say data principal, that means any Indian individual who is receiving any service or goods from any of the organization, and in and they are sharing their personal data to receive these services from them. So this regulation is giving a ownership to the individuals, that you are the owner of this personal data, and you can decide how this personal data can be consumed by the organization from whom you are receiving these services. So that's important, that data principle also understand this kind of regulation. And I see many of the legal and advocate firm in India, they are raising awareness. If I compare with any other regulation introduced in India, I haven't seen this kind of big campaign in India uh, for any other regulation. But this is also important, that every individual or data principal will be, receiving this kind of awareness, and they will use their rights carefully. So it's important for organization to understand this law as soon as it will applicable. But before that, they need to be ready, and they need to see what capabilities and tools and mechanism they already have in place, so they can utilize them and be ready for the compliance of this new data protection law in India. So to do that, they really need to understand if this law is applicable to them. And when it comes to the applicability, uh, it is applicable to every organization who process personal data and operating within India, but also to the other organization who are not operating in India, but they are serving to Indian citizens. They are also obliged to implement data protection law 2023. Uh, to do that, they have to plan how strategically they can initiate a data privacy program, and for that, I think they really need a organization like your organization, Naveen, where you could extend the expertise and help them to build and demonstrate that these organizations are compliant against this applicable law. And um, and it is, this law is actually a little bit different from the rest of the data protection laws across world, because it is introducing a couple of roles. One of them is the consent manager, and another one is for significant data fiduciaries, actually data protection officer role. and also a role called auditor, data privacy auditor. So there will be a lot of new roles coming up in the Indian market, where organization would be looking for auditors and consent managers and data protection officers. So there is a proper need to implement data privacy program. If organization already compliant against regulation like GDPR, they also need to perform a assessment or an assessment and see that if GDPR they are compliant against, then what is the delta they need to address, and which will help them to compliant against this data protection law in India. So that exercise really need to be done by these organizations, and in DPDPA term we call them data fiduciary. Yeah, let's go to the next slide here. As Naveen, you mentioned that this regulation also impose some penalties if the data fiduciary they are not able to demonstrate that they are compliant, or if there is a negligence around processing of any personal data. And it depends what is the number of this penalty. It depends what kind of scenario the organization being non-compliant. It's not that there is a breach, or if there is a non-compliance that data protection board will impose 250 crore directly. It is depends that what kind of issues and scenario was it. And the beauty of the law is it is not giving 100% faith or trust towards the data principal or individual. It is also lying some responsibility to this role. It is asking data principal or individual that it's your obligation or your responsibility to produce true data to the organizations. If you think that the data is not true, this law is giving some rights to the individual so that they can update this data, or correct this data, or if it is not needed anymore, they could also ask to delete this data and so on. So we will talk about the data individuals or data principal rights in the later slides. So
I'll just add on this slide if it is okay, so if you can allow.
Yeah, please.
So this is important. This slide basically gives a view that how much critical data privacy is going to be for our Indian corporates and enterprises. We process a lot of personal data. Now, it could be those companies who process foreign data because of their BPO operations. And it is applicable absolutely to entire medical industry. If you see, the hospitals, they capture personal data. And I can quote an example wherein I visited one of the hospital, and all of a sudden, when I came out of that, a very renowned hospital, okay, and I went for a checkup, and when I came out, within 15 minutes, I started getting messages from third parties regarding that disease, and we can help you recover that. That was shocking. I mean, please understand, I visited the hospital, half an hour I'm out, I'm driving back home, and my data is already leaked. And I'm talking about some very, very big hospitals today. So the way the corporates handle the data, and medical data is absolutely critical. It cannot be disclosed to any person, be it my any disease that could be, right. So all these organizations, out of ignorance today, they are highly vulnerable. So my message here is that some of the industries are very highly vulnerable if you don't understand the data privacy properly. Data, personal data has to be maintained with a lot of controls, and there are various ways and means to see to it, how it is to be done, how it is to be handled if the breach happens, what is to be done. That's all around the governance and the framework which you are talking about right now. And implications are severe. It talks about 200 crore, 250 crore. I mean, it's going to be really serious matter. It's also opportunity for new roles. We saw some opportunities coming from a bank, a government bank, asking for data protection officers. DPO. So I'm saying that it's a opportunity, right, from the professionals to upgrade themselves to data privacy so that they can get some future roles in organizations and even government also. And it's important for all the Indian, I say, our enterprises and customers to immediately go through the awareness programs and understand what are the typical controls they need to implement to see to it the data they handle is secure to the extent of what the DPDPA law says. So it's a right time for organizations to get into it. People can prepare as a professional career, and organizations can start audits. I think it starts with the auditor who can just tell you what is the problem area, what is the data which you need to manage or you need to handle carefully. Uh, so I think the slide summarizes government's intent on this area.
Yeah,
Thank you.
yeah, yeah. And I just add to it, Naveen. I think this is the right time and actually an opportunity for businesses to address their legacy issues. For example, if they have issues in their maintaining their customer databases, or if they have issues in maintaining their billing systems, or 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 their invoicing data, this is the right time for businesses to address these kind of issues along with when they will be implementing data protection law. And there should not be a different efforts to be aligned to these kind of legacy issues. They can take this along with while discovering data for this data protection law, and they can address those legacies issues now. So I think this is a good opportunity for the businesses. Yeah, can we go to the next slide, please? Yeah, we have been talking about these terms, and let me go through this quickly. The digital data, if you see on screen, under this regulation is only applicable to the digital data, and the data which is written on paper but eventually will be automated and digitized in digital form. So this law is not applicable on the manual data which is existing on paper, but it actually on the digital data. We call data fiduciary when any organization or any person or any entity who is actually collecting data directly from individuals and then deciding how it is to be processed and what purpose this data has been collected for, and the services given to individuals according to that purpose. So the decision being made by this organization, and they are called data fiduciaries. Then we have a term called data processor. So any any other entity, any person or organization who are supporting this data fiduciary to carry out their operations, but they do not decide how this data will be processed, for what purpose it should be processed. The decision will be made by data fiduciary and instructed to the data processors, and then data processor will oblige to adhere the instruction coming from data fiduciary. So eventually the accountability of the data processing will go to the data fiduciary. And when I say data processing, it's a very broad term where if you if you delete data, see data, update data, modify it, uh, purge it, merge it, or juggle it, whatever you do with data, we call it data processing. Then we have another term called data protection board. So Government of India, as per the data protection law, is mandating to formalize a data protection board who will oversee the implementation and also monitor the progress around the data protection regulation, how it is being implemented by organization. They are also eligible to impose the penalties. They are also eligible to go and conduct audit if there is any complaint raised by data principals or individuals that my data not processed responsibly. Then data protection board can initiate a audit towards data fiduciary or data processor. I hope you understand already what is data principle. So principle is individual of India whose data will be processed by data fiduciary. And there is another term called data protection impact assessment. And this data protection impact assessment is an exercise, comprehensive exercise, which need to be performed by data fiduciary if they are processing sensitive data and data at a very large scale level. Then they need to conduct an assessment and see if this data being processed in this way, uh, how it is having an impact on data principle. So they just try to identify the risk, data privacy risk, and try to mitigate them. Let me go to the next slide, please. Yeah. So we already talked about DPDPA 23 and a couple of component this contains, and these components are actually being fair, being transparent with the individual whose data will be processed. So data fiduciary has to produce a privacy notice when they will be taking a consent from individual or data principal that we will be processing your data. Let's take an example. If you go to any bank and if you ask for opening a saving account there, the bank might ask you some data to open this saving account, and this data is collected only to operate the saving account. The purpose to collect this personal data is to operate saving account. But later on, bank decides, okay, I also would like to sell my insurances to this data principal, and their personal data is already with us. Let's go and sell this insurance also to this data principal. That is not according to the law. Bank has to collect another consent because they are changing the purpose to process this data. They also need to contact to individual that we collected your personal data while open your saving bank. Can we also sell some other products of our bank to you? If individuals say that yes, you can do that, then bank is eligible to call them or sell their other products. Otherwise, no. So see here, individual is actually owner of the data. Also can produce a consent. Yes, you can call me or not call me, and that's why they can enjoy their freedom. So that's the main purpose of the law, to give the ownership to the individual of their personal data. So these are the couple of component of the data protection law. Lawfulness and consent management is one of them. The data principal rights, individuals' rights, what rights they can have while taking services from any of the data fiduciaries. So they can ask to have access to their data, that please tell me what data you process about me, or I do not want to extend my consent anymore. Please, I want to withdraw my consent. Then they can do it. They can also say, I am not available. I am just introducing my nominee. Can you consider my nominee? He can take actions behalf of me. And data principal can also say that I would like to I would like you to erase my data and delete my data. Then data fiduciary has to follow all these and take an action. And it should not be so difficult for data individual to exercise their rights. It should be very simple way. So data fiduciary has to produce a mechanism where data principal can exercise their rights. So now we are studying about this data protection law, but it would be difficult for organization to implement this on ground. Uh, when this law is saying, okay, data fiduciary has to produce privacy notice when they will be taking a consent from data principal, then how do you do that when you have a product? Can you do that when they are trying to sign into your portal, or when they try to use your product? So what is the mechanism to introduce the privacy notice? and what should be the wording of the consents and everything. So here the consulting firm, they are helping organization to enable them to introduce privacy notices and prepare consents and track the consents and all that, prepare the policies and procedures for them. So all these are the different components of the data protection law here. Technical organizational measures and implementing data management. Also very important is to design a data breach management process. So it is an obligation on data fiduciary. If there is a data breach, they are obliged to inform to the data protection board within a stipulated time, and if needed to the data principal as well. So this time is not yet defined by the law yet. It will be coming soon. Government is working towards it to define some rules, and those rules are not published yet. Uh, so there are a couple of outcome from this. Data fiduciary has to enable data principal how they can exercise their rights. So data fiduciaries somehow need to create a kind of platform onto their website, or data principal can call them that I would like to exercise these rights, and within a stipulated time they have to respond back to data principal that this is what you have requested for, and we have taken this action. This is what the result is. Data fiduciary has to somehow demonstrate that they have implemented all the security and organizational control. Those are there in place. So there are some assurance reports in market like ISA 3000, or Luxembourg Data Protection Authority also introduced a certificate where um, you can opt for that to showcase that you are compliant. Also in India, DSCI is also introducing, and I think they already introduced a privacy seal, where organization can take those privacy seal and demonstrate that, yeah, we are compliant against this data protection law. So this is how organization can showcase that they are serious about implementing this data protection law. Can we go to the next slide, please? Yeah. Uh, So this we already talked about the applicability of the data protection law. It is actually on the digital form of the data, and exception also, there are some exceptions. Manual processing of data is not under the scope of this law. Uh, if personal data, uh, shared by any individual voluntarily or for their personal use. For example, you are just uploading your photograph on one of the social media. You are, you know, you are just publishing this personal data yourself. That will not under the scope of this law. However, we cannot take out the applicability of this law to the social media platform owners. They are responsible to protect your data, and not to share this data with someone else without your consent. So uh, that's how this is being designed, that who is data fiduciary and who is the owner of this data. So it means to say, if you are using this personal data and this personal data is your domestic use, your family or your own data, and you are publishing it voluntarily or by your own wish, then it is not in the scope of this law. And if personal data that has been existence and on record for at least 100 years, then after 100 years, this law will not be applicable to you, or on this data. Yeah. So we already talked about this couple of terminology called consent, privacy notice, and deemed consent. So consent mean when any individual or data principal, they are giving the consent or giving their permission to the data fiduciary that you can process my data. uh, it is a signal to them, okay, go ahead and process my personal data, and maybe then they will receive some services from the data fiduciary. But that's how this agreement will be between them, that yeah, my consent is with you, process my data. But if later this data principal says that no, I don't want to use your service. Please, uh, from today or now onwards, do not use my personal data. Then there is a role coming up called consent manager. That consent manager will entertain this request and keep the records up to date. Data protection board can ask any organization that do you have a consent manager role? Either it is a human being who is playing this role or a system. IT system can also become a consent manager. So uh, fiduciary data fiduciary has to produce some kind of evidences that yeah, we are maintaining this and we are acting upon it. But generally data protection board will only come to and ask to data fiduciary if there is a complaint from data principal. When we talk about the privacy notice, the privacy notice is not kind of very extensive documentation or something. It is just a way to tell to data principal, we are being transparent. We have taken these steps to protect your data, and we will be processing your data only for the purpose we collected for. And you will be you can be or we can assure that this data is with us and we will not share it with any of others without your permission. So this privacy notice a kind of wordings written by data fiduciary to give the confidence and will be transparent with the individual that yeah, this is these are the scenarios we will be using your data or consuming your data. You don't have to worry, and these are the contact information of our consent manager or data protection officer. If you would like to get in touch with us, you can you can come to us using these telephone lines or email address or filling a form or kind of stuff. Then it comes to the deemed consent. Deemed consent is actually a kind of legitimate interest of the data fiduciary. If data fiduciary think that the data which is related to any individual, and if it will be used by uh, fiduciary for public interest activities, then fiduciary do not need to take a consent from individual. Let's take an example of the COVID scenario. When we have taken a different brand's vaccination, then government has analyzed by putting this vaccination to individuals, they are recovering fast, or using this another vaccination, they have a different kind of impact. So in that case, government decided not to inform to the individuals or data principal that we are utilizing your data, but they have consumed or utilized it because it was in the public interest. It was for the public interest. So in these kind of scenarios, a deemed consent can be considered, and data fiduciary can utilize this data, but uh, they have to conduct a kind of legitimate impact assessment to showcase that we have been responsible and we think that let me conduct an assessment and you don't have any impact when we process your data. So this kind of best practice need to be adhered by data fiduciaries when they consume data about the data principles. Yeah. So I think we already gone through these terms, but there are some obligations around it. Data fiduciary, they need to be responsible. They need to be transparent. They have to respect the individual's rights, and they are the one who has to report to the data breach to the data protection board. But significant data fiduciaries, they are actually the one who process sensitive personal data and also personal data on a large scale basis. But they could be asked to have a data protection officer in place and also a consent manager in place and an auditor. But data process and data principles, they are the same. They are just following the instruction coming from data fiduciary, and data principal have their rights. Let me go to the next slide here. Yeah, these rights, I think we already gone through. Right to inform, right to correct and eraser, right to grievance redressal, and right to nominate. So here, data principal can exercise these rights, and data fiduciary is obligated to receive this request and act upon it. In GDPR, it is 30 days, but here you might have a different timelines. Data protection board we already talked about. So data protection board is more around monitoring the compliance and imposing penalties on data fiduciary if there is a non-compliance against the applicable regulation. And they can also inform to data principal that we have taken action around it, and they can also impose this penalty, and this penalty will be utilized to improve the compliance and monitoring part of the regulation. Yeah, let me go to the next slide here. So
So thanks,
over to
Sudhir.
you,
Yeah,
Naveen sir. Yeah.
yeah, thanks, Sudhir. So I hope, we were able to summarize what Data Privacy Act means to us from Indian perspective, and the kind of implications it may have on our business in India. Okay, so a little bit about our organization. So basically, we are based out of Gurgaon, and we are a system integration organization, primarily focusing on solutions in the digital workplace. And security is one of the key portfolios for which we have collaboration with Cyberspile. So Cyberspile is an organization which operates out of Norway, and they are focusing big way on GDPR from a Europe compliance perspective. And the Indian arm is basically focusing on the DPDPA and other related uh, uh, issues around data governance and data protection. So the key area which we focus here are data privacy, data protection, and data governance. Data governance is a big problem today. I think I know based on my experience, I've worked with large corporates and have been into deep into operations and deliveries of large customers. So I can see that we struggle today in terms of understanding how many copies of one critical data is lying and where they are lying today is mismanaged today. Very difficult to find the latest version. You see it on a daily basis. So data governance and how we handle data once you have received the data, where we have to keep it, we have to share it, when we have to delete it. This is a big area, and Sudeep talked about it that when we are fixing our data privacy issues, so why not to look at our overall data handling and data governance, which includes handling your customer data, a common baseline. So if you ask any customer, do they have a single master data of their employees? Answer maybe no. There could be multiple databases. So master database, I'm talking about large corporates, is a serious problem when it comes to finance or HR or any other large function. So it's an opportunity to see to it that while we do I'll say audit of our data, we get into details of other aspects of data governance also. So we are coming up with a very interesting framework on security called Data Fortress, wherein we are trying to address all customer concerns. So our next webinar is going to be on Data Fortress, wherein we are covering the data security or data specific governance through a data fortress model, which talks about data security, data privacy, data protection, governance. So a customer gets a platform wherein he can take care of his entire data end to end. And for the awareness part, we have this cyberspile compliance school, which will be launching multiple courses around awareness, which are required for the DPDPA adoption. So some of the courses are mentioned here. So we continue to focus on the awareness and on the audit area in the starting and helping customers to know what is required in terms of ensuring the compliance. So I talked about our capabilities. So we are into infrastructure, application. So from the layer one to all 7 layers, we try and give solutions to our customers. We are into managed services business, so a lot of human capital assistance. We have a large team. We talked about cyber security, data privacy and protection through our data fortress model, and we have a compliance school for the trainings part and the integration. We address solutions on mailing, cloud services, and any other technology system integration. So basically, I mean, I think our objective today was to see to it that we start our awareness around data privacy, and our India operations. You can reach out to us uh, for any help, any audit, or any further awareness sessions. We are more than willing to help you people in terms of understanding the implications of data privacy with respect to your business. The compliance requirements will be uh, different for different businesses. Okay. So thanks everyone, and thanks Sudhir for your precious time. And Mehak, I think we have certain questions. What we can do is we can take some questions. We have 5 minutes left for the webinar here.
Thank you so much, Mr. Sudhir. Thank you so much, Mr. Sudhir and Mr. Naveen. Dear all, I hope this session was helpful to you all in gaining a clarity of this new act. Now let us move forward to our Q&A session. We have received few questions, so let's start now. The first question that I've received is, how should organizations respond to and report the data breaches?
Yeah, I think that's a very interesting one and critical one. Organization should understand first what is the difference between a security incident and data breach. It's a very thin line, and security incidents comes first because the three pillars of the security, CIA, confidentiality, integrity, and availability. If any of this pillar is down and a data has been accessed, that become a data breach. So if any of this pillar is down, that become a security incident. And after this incident, if data is being accessed by any unauthorized person and who is not supposed to see it, then it becomes a data breach. And organization has to understand this when they differentiate between these incidents. Data protection board is still writing rules that what is the timelines for the data fiduciaries to report to these data breaches to the data protection board, and that will be introduced by government soon. We have been waiting for that. So let's wait and see what is the timeline defined by the government on it. Yeah.
All right. There is one more question that I've received multiple times. How can organization ensure that employees are educated about DPDPA and data privacy's best practices?
Yeah. So awareness is the first, word which is coming in my mind. Employee has to understand that what type of data they are entertaining or operating on daily basis, and they also need to understand what is the misuse of this data. Generally, they even don't consider that if they are sharing a salary slip of another colleague to someone else out of our organization, that this is a data breach because it is not authorized by the individual whose salary slip is being shared. Employees has to understand that what are the data they are operating on and what are the data breaches scenarios or something like this. So awareness training and some sort of campaign or these kind of initiatives can help employee to gain some knowledge about the data protection and what data they are processing. That's the only way. And I think Naveen just mentioned that Cyber Spy Compliance School is introducing a couple of courses, and awareness is one of the courses of these initiatives.
So maybe we can take one last question.
Yes, with time being short, there is one more question. When is it mandatory to appoint a DPO and what are their responsibilities?
Yeah, let me take that as well. So, data protection officer, according to the DPDPA 23 in India, uh, significant data fiduciary when they are processing sensitive personal data and personal data on large scale basis, they are obliged to appoint a data protection officer, and this data protection officer will act as an independent role where this data protection officer is not responsible to implement the law, however, can be an advisor how to implement it, and can be an auditor or assessor that how this has been implemented the organization. And data protection officer is actually an interface between data protection board and data fiduciary. If there is any data breach, it should have been, or it should be communicated by data protection officer to the data protection board. So there are a couple of responsibilities laid down by this data protection regulation for data protection officer. It can be read in the regulation as well.
Thank you.
Yeah.
With time running out, I guess we'll have to bring the Q&A session to a closure right now. We will be responding the remaining questions via email. And I would like to thank both of our speakers for sharing their views on the Personal Data Protection Act, drawing from their experiences and expertise in this domain to our audience. I hope this you found this webinar interesting and worthwhile for the investment of your time. Please do not hesitate to contact us regarding any matter arising from this webinar. Our contact information was reflected during the webinar. Thank you now for attending today, and we look forward to seeing you again very soon. Thank you very
Thank
much.
you.
Yeah,
Thank you,
yeah, thanks,
everyone.
Mac.
And
Thanks, everyone. Thank you so much for joining.
thank you, everyone. Nice to interact with you. Have a nice day ahead.
Thank you.